Good afternoon, everyone. I'm Hilda, and I work here at the Office of Civics and Community Services at the Los Angeles Public Library. Welcome to our Know Your Rights series, Know Your Housing Rights series, excuse me. Today's program is called Estate Planning and is brought to you by the Housing and Economic Rights Advocates, as well as the Los Angeles Public Library. Today, Kendra Bowen from HERA will discuss the basics of how to set up an estate plan to prepare for the management of your assets during your lifetime if you can no longer take care of them yourself, and set up a plan for the distribution of your assets following your death. We will have a brief Q&A after the presentation, so please send us your questions throughout the program, and Kendra will be able to answer them at the end of the program. Take it away, Kendra.
Thank you so much, Hilda. Can everyone hear me okay? All right, great. So as Hilda said, my name is Kendra Bowen. I'm an estate planning attorney with HERA, and I'm delighted to be here with you today. As Hilda said, we are going to discuss estate planning, and HERA set up this estate planning department, close to 10 years ago. HERA does a lot of work to help folks with housing issues, HOA problems, mortgage foreclosure problems, loan modifications, that it made sense to help preserve that family wealth in the house and make sure that it goes to the next generation the easiest and least expensive way possible. So today we're going to discuss a couple of parts of estate planning. The part of it that does concern what happens when people pass away and how do they distribute their wealth. But the other part of estate planning deals with what happens in the later stages in life if we lose capacity. Can we have certain documents in place to cover medical advocacy that might need to be done on our behalf, and financial tasks that would also need to be completed by someone else if we were not able to do so? So we're going to discuss all of this today. Next slide, please. We're going to jump right in here and discuss the what, who, when, why, and where of estate planning. This is a little bit more information about HERA. Again, most of the work we do as a law firm is provide free and low-cost legal advice for tenants, homeowners, people who have been subject to even identity theft types of issues. So we really do a lot to deal with housing issues and financial issues. Next slide, please. And again. All right, so next slide. So we're going to discuss a couple of myths about estate planning. These tend to be barriers as to why people don't do their estate planning and why their family doesn't think about doing it until perhaps it's too late. So some people say, I'm going to rent for most of my life here in California. I don't really have major assets, so therefore I don't need estate planning. Well, you will hopefully find out and discover throughout this presentation that that is false, because as I indicated earlier, part of estate planning deals with what happens to our financial lives and our health care as we age. And let's say we have dementia. We need documents in place to make sure that our wishes will take place down the road, as opposed to someone else imposing what they want for us down the road. Next slide, please. Another myth is that people understand that California does have a mechanism for property to go perhaps to the next generation. It's often called probate when a house is involved, and it's very expensive. But let's say a single parent passes away and has 3 kids. If they don't do anything, the assets will likely go to all 3 children by virtue of California law. However, if you have 3 kids and for whatever reason want your home to go to only one of them, that child's been helping you or whatever the arrangement is there, that is absolutely fine, but you must indicate in a properly executed written document, a trust or a will, that this is your desire. Otherwise, that is not what will take place. Next slide. Another myth is that people will indicate that they're done with their estate planning because they have a will. They were going on a trip and they executed a will the week before, and their family will not need to deal with probate because they have a written will. Well, in California, what you will discover as we continue on together is that just having a will, especially for homeowners, is not enough, and it certainly does not avoid the probate process that we have here. So while a will might be part of the estate plan, it won't be the entire estate plan. In addition, a will only kicks in when people pass away. We care about folks while they're alive and perhaps compromised in some way. They have dementia, and we want to make sure that people have in place the documents that will cover situations and declines in life while someone is alive yet compromised. And we have documents to cover that. A will does not. Next slide. Another myth is that people understand their family dynamics, we hope, and sometimes think that their kids get along so well that everyone understands what is to take place when they pass away one day. And that's what's going to happen. Well, we've all heard of instances, or maybe have seen them with our own two eyes, of a parent passing away and kids getting involved, and even their spouses becoming involved. The worst of people tends to come out. And we want to help keep the family peace even when we're no longer here. And it's best to have all of our intentions spelled out in properly executed estate planning documents. Next slide. So we do estate planning while we are feeling good and with it. It's a process that involves the people in our circle and our property. And we prepare these documents now to address the future needs. By the time we need these documents, that window will have passed for us to create these documents. And as I indicated earlier, a will is okay sometimes, but it is not a full estate plan by any means. Next slide. Next slide. There we go. All right. So as I indicated, there are two different groups of documents. The documents in blue on the left side of the page are documents that are really important while we're alive, that really kick into gear while we're alive, yet we are somehow compromised. We have dementia, we've been in an accident, we're having to take a whole lot of medications that cause us to be out of it. So on the left in blue on the top, we have a durable power of attorney for financial purposes. That is a document where you are going to nominate someone to take over your finances if you are not able to take care of those yourself. The trust, the middle box, is important with respect to trust assets. In a trust, we nominate someone to take care of trust assets while we're alive, if once again we're out of it and can't take care of our property taxes and our home, etc. Keep in mind that trust is always changeable by you. As long as you're alive and with it, you can always change the terms of your trust. It pops over to the right-hand side and becomes an at-death document when you pass away. Once someone passes away, their trust cannot be changed by anyone, and it will thereafter distribute assets. Let's go back on the left, though. Another important document while we're alive yet incapacitated is an advanced healthcare directive. And that's a document where you will nominate an agent to advocate for you in a medical setting if physicians cannot effectively communicate with you. Okay. So on the left, our document's important while we're alive. The power of attorney and healthcare directive go away when we pass away. When we pass away, all we have left that's effective is a trust and a will. Those two documents distribute assets at death. Next slide. Typically, estate planning attorneys prepare these documents. If you need a full estate plan, it is important to make sure that the individual preparing the documents is an attorney licensed to practice in the state of California. If they are not, they cannot prepare your estate planning documents, and you really wouldn't want them to do so because there are certain peculiarities that we have with estate planning here in California. Likewise, you don't want a lay person or a notary public or a paralegal to be planning your estate planning documents or to be preparing them. While a notary is needed at the end to notarize these documents, they do not understand typically the implications of community property and other things that are important to make sure that you have a good foolproof estate plan. Next slide, please. So we need estate planning because of two main reasons: to plan for incapacity down the road and to plan for what is going to take place one day when we pass away, where our assets going to go, who is in charge of that process, and who would be in charge of any minor children or dependent adults at that stage. Next slide. So the first group of issues and documents we're going to review and look at are going to be the documents that are effective when we pass away. Next slide, please. So as I indicated earlier, in California, we have an expensive, lengthy probate process. And probate is the process that loved ones or an estate needs to undergo in order to transfer title of assets. So in California, if you own assets gross, so in total that exceed $184,500, if you pass away and you don't have a trust or some other mechanism to avoid probate, your family will need to go through the probate process. Next slide, please. So that's very important in California. And probate is something we want to avoid because typically to go through probate, it is necessary to hire an estate planning attorney to lead your loved ones through that process. There are court appearances that are required. All of that can be avoided by utilizing some of these tools. And again, you don't need to know what tools are needed in your situation. We're just trying to touch on some of the tools available. When you meet with an estate planning attorney, they'll be able to really help you decide what tool is appropriate for your assets in your family situation. So on the top row, and these are all ways to avoid probate. On the top row in the upper left, we have completing a revocable trust. If someone completes a trust and let's say puts their home in their trust, if they are there to pass away, typically a probate is not needed. That essentially bills are paid and then the distribution of assets can take place. The second bubble from the left is holding real property, a home, condo, townhouse, in a transfer on death deed. So this is just an additional deed that only deals, of course, with real property in California. And you can actually put a beneficiary down on a piece of property. If you were to pass away and that beneficiary is alive, you have avoided probate because that property will go to that beneficiary. Looking at the upper row, second from the right, with respect to account, so an investment account, bank account, you can actually sometimes place PODs, pay on death designees, on those assets. And if you were to pass away, as long as one of those beneficiaries is alive, that account will go to that beneficiary. And then on the far right of the upper row, we can have assets that altogether do not exceed $184,500, essentially don't own a home in California. All right, so let's look at the bottom row. Let's look at the far left and the middle bubble on the bottom row. If you own real property, a home, condo, or townhome, and own it with your spouse as community property or with your sibling as joint tenants, as to the first death, that home will be protected likely from probate, because when one person dies and they own a home with another as joint tenants or community property with right or survivorship, there will not be a probate to transfer it to that other person on the deed. However, the last person standing needs to actively do something so that when they die, there's no probate. And then let's look at the bottom bubble on the far right. Retirement plans, life insurance, any kind of other death benefits. Typically, you will just name a beneficiary on these assets, and that will avoid probate as long as one of those beneficiaries is alive at the time that you pass away. So we have many different tools to deal with different types of assets here in California. Next slide, please. We're going to first look at the revocable trust. Next slide. And the main thing with the trust to keep in mind is when a lawyer creates a trust, you are the trust if you've created it. You own all the property in your trust, your bank account, your home. You can sell it without being accountable to anyone mentioned in the document. You don't even have to keep track of what you're doing. It's all your property until the day that you pass away. So in a trust, you are the grantor, grantee, trustor, trustee, settlor, beneficiary. You're everything because all that property is still yours. You just hold title to it a little bit differently than you did previously from having a trust. The trust can be called all different things, a trust agreement, declaration of trust. The main thing you want to make sure of is that it is revocable, because while you're alive, you can always change your decisions. You can state that you want everything to go equally to all three kids right now, and then in 5 years state that you want everything to only go to 2 of your kids, and you can disinherit the third kid. You can do whatever you want, and the copy of the trust is not given to beneficiaries, let's say kids in this case, until you pass away. In the trust, we have no contest language and accounting language and spendthrift language. All of this makes sure that everything is yours and no one can encroach on your rights to the property until you pass away. Next slide, please. So let's look at the difference between holding, let's say, a piece of property in a trust and passing away, and only having a will or having no will and then pass it away. So if you had a trust and properly placed your home into that trust and then passed away, we're looking at the left-hand side, there's no probate needed. It is a private record, so no one will really be entitled to see where your assets go. There are no statutorily guaranteed fees to attorneys or to your personal representative. The assets in the trust are not subject to estate recovery, and it just takes a shorter amount of time and less money to administer a trust. Let's look at the right-hand side. Let's say you had a will and you pass away and you happen to own a $500,000 condo. There will be a probate. That probate is public. If you had a will, the will would actually be public because a will is actually filed with the probate court. A trust is not filed. So people can find out where your condo is going to go. There is compensation, statutory compensation, guaranteed to go to an attorney and to a personal representative. You're paying them to conduct various tasks under court supervision, so they're going to get paid. The assets are subject to estate recovery, and this is in case any medical claims are paid on behalf of the decedent. And it just takes less money it takes more money to probate a will, and it takes at least a year and a day. So we rather have to go through the process on the left rather than on the right, which involves probate and will, which again is expensive and just takes more time and money. Next slide, please. For those of you, if you remember that one bubble that states if you own assets that are less than $184,500, so you rent, you have a little bit of money in your account, it's okay to just do a will. You don't have to do a trust. So a will can distribute assets and appoint a guardian. You just need to make sure that your assets don't exceed that threshold amount, or else you will prompt a probate in your family when you pass away. Next slide, please. Probate is expensive because you're going through a court supervised process first, transferring a person's estate to the beneficiaries. The court will validate the will. They'll appoint a personal representative and require a lot of other formalities to just end up creating a lot of expense for an estate. Next slide, please. So in California, if you don't take the time to state who you want to take over distributing your assets when you pass away, or even who your beneficiaries are going to go when you pass away. So if you don't execute a will or a trust indicating your preferences, as I indicated earlier, the state of California does have a mechanism for doing so for people who don't take the time now to do that. So typically a surviving spouse will be nominated as the person to take over an estate. If there is no partner, it will be children or grandchildren or your parents or your siblings. If this is not what you want to have happen, it's important to create at least a will and maybe a trust if you're a homeowner to make sure that your intentions one day take place rather than the state of California's default scenario. Next slide. These are a few of the things that a personal representative and their attorney will need to do if there is a probate. So, and this is why it costs quite a bit of money to go through when someone passes away. So first they need to file a petition for probate. Then they need to publish different notices and present them to various people. They may need to file a bond. They'll have to obtain a hearing date on the petition for probate. They'll have to prepare an inventory and appraisal, and that will all be sent to a probate referee. They need to give notice to known creditors, pay debts, file taxes, file an accounting and final petition for a final distribution with the court, mail notices to various people, obtain a hearing date so that the judge can sign the final distribution, distribute assets, and then finally, hopefully, file a declaration for final discharge from the probate. These are just a few of the tasks that a personal representative and their attorney will need to do, and it is a much more streamlined Method, if you have a trust and just need to do a trust administration, you really do not have to do all of these court appearances and filings with the court. Next slide, please. The statutory fees that we discussed. So these are the fees that will be taken out of an estate if there's a probate. So let's say we have that same $500,000 condo, and let's say the loan against the condo is $400,000. So there's equity in that condo, and it's the only asset of the estate of $100,000. Okay. You would think, oh, it's under $184,500. There's no probate. Incorrect. The probate court looks at the value of that condo and does not consider the loan against that condo, the mortgage against it. So they view a decedent who has a $500,000 condo with a loan of $400,000 as owning a condo worth $500,000. So if you go across the $500,000 line, I believe it's the fourth one down, you will see that the probate fee for an estate that has a $500,000 condo is $13,000 to the attorney having to handle that probate, and another $13,000 to go to the personal representative handling that probate. This excludes court filing fees, all of which seem to be between $400 and $500 for various things. It does not include the probate referee fees, different paralegal fees, tax prep fees. So this can really add up and be quite a bit that is removed from the decedent's estate. This will be paid off the top before a distribution to beneficiaries. Next slide. So we're going to look at this example. So once again, on the left, we have a trust administration situation. With this example, we have a house that's worth $1 million and has a loan against it of $300,000. So the net value is $700,000. And this is when someone passes away. Let's say the house needs to be sold. There are some staging costs of administration. And so $20,000 is taken off of that. And in the end, on the trust administration side on the left, $680,000 will be distributed to loved ones, whatever the trust states. Let's look at the probate side. We have that same fair market value of $1 million with the loan against the home of $300,000. So we have a net value of $700,000. $20,000 will be taken off for staging and other costs to, let's say, sell that $1 million piece of real property. But because there needs to be a probate with respect to the people who are doing the process on the right-hand side, $23,000 will be taken off and given to a personal representative, and $23,000 will likewise be given to their attorney. So the distributable balance here is $46,000 less than the trust side. $634,000 is the amount that will be distributed to the loved ones there. So there's a pretty big difference. Close to $50,000 is saved because this individual did a trust on the left versus the person who forced their family to go through probate on the right. Next slide, please. One more example. Okay, so we have Pamela, and she has a house, and her deed states that she owns it as trustee of her trust. She has 2 retirement accounts and put Ben as a beneficiary on those accounts, her, I guess, younger brother, Ben. And she had a life insurance policy, and she indicated that her mother was the first beneficiary of her life insurance and that her younger brother, Leo, was the second named beneficiary on her life insurance policy. She also had a checking and savings account of $2,000, and she put down that Tommy was the beneficiary there. A POD, pay on death, was Tommy. So in this example, do we think that there is a probate needed? And you could put your answers in the chat if you would like to do so. I don't know if there is a communal chat. Okay, so we're just going to go on the honor system here. All right, next slide. Pamela really did everything correctly. There is no probate proceeding needed here because she owned her home as trustee of her trust. She had a living beneficiary on her retirement accounts. She even had a living beneficiary on her life insurance, and she had a pay on death designee on her bank account. She did everything correctly. Next slide, please. Let's look at Alex's situation. So Alex passed away, and he also had a house worth $300,000. His deed stated that he owned his house as an unmarried man, not in a trust. He has a couple of retirement accounts, and he forgot to put a beneficiary on those. He has a life insurance policy. He only named an older person to be a beneficiary, and unfortunately, that older parent passed away before Alex did, so there was no second beneficiary that would have been effective when he died on his life insurance policy. And with respect to his bank accounts, he indicated my girlfriend was the beneficiary there. Pretty ambiguous because many people claimed to be his girlfriend. So in Alex's situation, do we think that there was a probate proceeding needed here? And next slide, please. Alex didn't do anything correctly. So his house is not in a trust. He doesn't have living beneficiaries on his retirement and life insurance policies. Even his checking and savings account would be subject to probate because he didn't have any clear beneficiary indicated. So because the estate is over $500,000, there's going to be probably around $50,000 here paid to lawyers, the court, and the personal representative. Okay, next slide, please. So we're going to look at this other cool tool that we have in California called a transfer on death deed. Next slide, please. This is a relatively new tool that we have here. And if for people who don't want to prepare a complete trust, and if their main asset is real property, they can execute this 2 to 3 page deed, put a beneficiary on it, and sign it with the notary and file it within 60 days of the notarization, and thereafter file it with the recorder's office. And when they pass away, as long as there is a living beneficiary on this deed, there will not be a probate. Next slide, please. And this is what it looks like. It's pretty straightforward. You just want to indicate the beneficiary by name. You can't just put all of my children, and you'll sign this in front of a notary. You can take a look. And next slide. All right, so believe it or not, that's the at death part of estate planning that we've touched upon. All the tools available to avoid probate. Now we're going to look at what are the documents that we need while we're alive, but let's say we're incapacitated for some reason. We have an accident, biking accident, car accident, we have Alzheimer's one day. So there are various documents that we need to make sure that our life will continue on as gracefully as possible during those stages of life. And next slide, please. So the documents that we're looking at here are a power of attorney for financial purposes and an advanced healthcare directive. Next slide. These are two very important documents. And once again, they're effective while you're alive and they go away when people pass away. So important things to think about here are that we can get as granular as needed on these documents. We can state that we prefer in-home care versus going to a facility. We can also state that we have an agent, a first agent, the person that we believe is the best adept at making financial decisions for us and healthcare decisions for us. But then we also need to consider having a backup or second agent. So keep in mind when you prepare your healthcare directive or power of attorney, hang on just a sec, I'm going to plug in and continue charging. There we go. I'm in good shape now. Keep in mind that when you're considering people in your circle for these potential roles of responsibility, you want to be brutally honest with the strengths and weaknesses of the people in your circle. So you don't necessarily have to choose your adult children in the order of age. You might have one child who is really good at paying his bills on time and who completes his taxes early. That would be a good choice for a power of attorney. But let's say that same child walks into a hospital room, was visiting a grandparent, 5 years ago, and became very queasy at the sight of IVs and blood being drawn, et cetera. That would not be a good choice for your advanced healthcare directive. So please try to assess very honestly, the strengths and weaknesses of your kids or anyone else that you're considering. You want to choose the people who are best suited for these roles of responsibility. And it is best to have a primary choice and at least one backup choice. We prepare these documents, a power of attorney and healthcare directive, while we're able to do so and while we're feeling good and are with it, to avoid a conservatorship hearing down the road in the event of incapacity. Next slide, please. Let's look a little more closely at the power of attorney for financial purposes. So this is a document where you will name someone, your agent, and it doesn't have to be a lawyer. It just needs to be the person that you trust to pay your bills and deal with Social Security and finish filing taxes. So that person would be your agent, someone that you know and is in your circle, a friend, a child, a partner. That person, you can indicate, would only be able to operate under the power of attorney. Let's say if the power of attorney was accompanied by 2 letters from doctors, which clearly stated that you were unable to take care of your financial affairs. That's called a springing power of attorney, and that is absolutely fine for it to not become effective until doctors clearly stated you, as the principal, can no longer handle your financial affairs. That's a springing power of attorney. The other type of power of attorney is an imminent or immediate power of attorney, where if I have a married couple and one of them tends to travel a lot, and they want to make sure that their spouse can do financial things for them if they're just out of the country. They don't need to be incapacitated. That would be called more of an immediate power of attorney, and that is fine in certain situations as well. It's really what's going to work out best for you and your circle and how you want those powers to be used one day. The power granted under a power of attorney can be general. You can let that agent do whatever's needed when the time comes. Or alternatively, you can really limit the authority of the agent. Your attorney will speak with you about the options there, but either one is valid. It's really going to be up to you. Next slide, please. Let's look at the healthcare directive. Okay. Like I said earlier, for all these documents, we want a first choice and hopefully a second choice. We want, I think, especially in the healthcare realm, someone who could stand up to someone on a medical team and advocate for you if you were medicated and could not do so yourself. We typically like people not to name co-agents, 2 people having to work at the same time. Time is of the essence with respect to a healthcare directive sometimes. And we don't want 2 people to be arguing about what they feel is the best course of treatment. You want to go typically with their first named agent to sign off on appropriate treatment, and then you certainly can, and we encourage you to do so, have a second named agent. With respect to the healthcare directive, I believe it's great if it's possible with your trusted people in your circle to have someone who could come to a hospital here in California within several hours to walk into your hospital room if needed, assess a medical situation, speak with your healthcare team face-to-face, and make good decisions for you. That person should obviously be an adult, and I think, frankly, 18 is pretty young. That's a hefty task to put on an 18-year-old, so a little bit older would be better. You may want to update a healthcare directive and a power of attorney if your circumstances change. So let's say you have a partner and something happens to the 2 of you in 5 years. Well, you probably want to update your documents to indicate any change in trust there. We encourage people to periodically review their healthcare directive, power of attorney, and their trust and will to make sure that every 2 years or so, it is reflecting what you want to have happen, take place. With respect to a healthcare directive, once you complete a healthcare directive, it's very important to, the next time you go to your primary care physician, Kaiser, Pam, Sutter, John Muir, to take a copy of it with you and make sure that they scan it into their system, because if there was a medical emergency and they did not have your medical directive, there would be a lag in medical treatment that would be approved for you. So it's really important that your healthcare providers have an updated version of your healthcare directive. Your medical team certainly does not need a copy of your power of attorney for financial purposes or will or trust. They only need your medical directive and the HIPAA that typically accompanies it. Next slide, please. We execute these documents, the power of attorney for financial purposes and the advanced healthcare directive, to avoid conservatorship down the road. So if someone becomes incapacitated, let's say has dementia, Alzheimer's, and does not have an advanced healthcare directive and does not have a durable power of attorney financial purposes, they very well may have a will, but the will unfortunately doesn't help while someone's alive. So if they are incapacitated and don't have the power of attorney for financial purposes nor a healthcare directive, there will be a conservatorship hearing in court. And typically what happens here is your immediate family is notified. So let's say you had 3 children and no spouse. All 3 kids would be notified. All 3 of them get to come to court, even with a lawyer, and try to convince the court that they would be the appropriate person to advocate for your medical care, to take care of your finances. While a judge is going to try to do the best they can for you, given a 2-hour hearing, I think it's much better if people themselves decide who they want in control of their finances and healthcare down the road, because you're the one that understands the nuances of your family, the dynamics, who would be the most reliable, etc. So if you please at least get those 2 documents finished sooner rather than later, at least you are assured that you will avoid a conservatorship hearing. Next slide, please. Some additional documents that you can have, and these are healthcare documents, are a POLST, a physician orders for life-sustaining treatment. So this document is absolutely fine for you to complete. However, please keep in mind that it does not take the place of a healthcare directive. A POLST is really more for emergency treatment. And for instance, with Alzheimer's, oftentimes there are not emergencies. And sometimes through a healthcare directive, you can indicate that if you have Alzheimer's and things are looking very dire, you don't want to be, force-fed and things like that. You can indicate that in your healthcare directive, where a POLST really doesn't allow for that. Likewise, some clients, when they reach certain stages of life, want to complete a pre-hospital DNR. So if they are undergoing some medical treatment and they need resuscitative measures, and they really don't want that because they're in pain all the time or whatever their medical situation is, it really zaps them of all quality of life, they can have completed a DNR with their physician, and the medical team should honor that in case there is a situation where resuscitative measures should be considered. Again, a DNR and POLST do not take the place of a medical directive, so you can certainly have all 3, but at a minimum, having an advanced healthcare directive is important, along with a HIPAA. The HIPAA allows physicians to speak with the people on your medical directive. Typically, physicians have obviously attorney, physician, patient privilege, but if you have executed a HIPAA, it allows the physicians to share some of your medical information with the agents on your medical directive without violating their duty to you for privacy. And next slide. So this is what a POLST looks like. And it's bright pink. Typically, frankly, it's like this because in nursing homes, if people want to have this document, it's meant to draw the attention of emergency personnel coming into a room and looking at it and making sure that they are not doing something to violate the indications set forth on this bright pink document. It doesn't have to be pink, but these typically are. And typically it's completed by someone of advanced age. And next slide, please. And then this is a DNR. This is a document that's typically completed with a physician, and you indicate, hey, when I go through procedures, if this happens, I don't want to be resuscitated. Again, this is something that would be, that is more commonly completed by someone of advanced age if the quality of life is not good. And next slide, please. Okay, so let's look at these different groups of documents together. So on the left, we have documents that are important while we're alive. and that would be the durable power of attorney for financial purposes. In that document, you're going to name someone that you trust to handle your finances if you weren't able to do so, and hopefully a second choice. That document goes away when you pass away. Let's look at the bottom left, blue. We have an advanced healthcare directive. That document will again have you appoint people that you trust to advocate for you in a medical setting. And it will have certain information there so that your medical team and your agent, as indicated by you on this document, know what your preferences are with respect to treatment that you want and treatment that you don't want. And then we also have a trust. A trust does not distribute anything until you pass away. But while you're alive, you can always change it. And the chosen agent of a trust, your successor trustee, could take care of your trust asset once again, typically your home, if you were incapacitated by virtue of a trust. So if you become incapacitated and you have a trust and your home, you own your home as trustee of your trustee could make sure that your home, the property taxes were appropriate and paid, et cetera, so that you could remain in your home or do whatever was needed to take the best care of you. When you pass away, the documents in blue go away and you have a trust, which is now never changeable because you're no longer here and you were always the only person who could change that document. So the trust will distribute your property privately and appoint guardians. And then you can have a will, and a will, as long as it doesn't deal with real property and assets it deals with assets that are under $184,500, it won't be the full probate that your loved ones would have to go through, but rather it's more of a form mini probate that isn't terribly cumbersome. So once again, the blue documents go away when we pass away, and it's just the trust and the will that are effective there. And next slide, please. For any of you who decide to proceed with estate planning with an attorney, typically what happens is you'll make an appointment. If you are married, it's important that you attend with your spouse, because if you're going to create a marital trust, if you have a home and you're going to create a marital trust, both of you need to be on the same page and first of all want to do that and have a similar idea about distribution at your deaths. You will provide some personal information to an attorney, but you certainly do not need to provide Social Security information or your account numbers or anything like that. Okay, so sometimes people wonder how much they'll have to disclose, and you're just going to share your family information, legal names of your kids, and a general idea about what you have, if you have a house, if you have retirement, those kinds of things. But we certainly don't need account numbers. That attorney will obtain some information about your choices, about people that you're choosing for potential roles of responsibility down the road, and will prepare some drafts. They will thereafter send you the drafts to review. You'll speak with the attorney either in person or over the phone or Zoom and review documents. If you want changes, you're certainly free to change them typically. And once you are satisfied with your documents, the attorney will send you documents ready to be notarized and witnessed, and of course, signed by you. So all of that will be orchestrated for you. The day that you have them notarized and witnessed, they are actually in effect. But at that point, it's important that if you created a trust, you fund your trust. If you owned a home, typically the attorney will prepare the new grant deed so that thereafter, at the time that you sign your trust, you will be signing your new deed so that you own your home as trustee of your trust. At least you know a big part of your estate has been funded to your trust and it will avoid probate. However, some of it you will need to do. So if you have bank accounts, you will need to retitle those to yourself as trustee of your trust. Very simple to do. You typically want an appointment with a personal banker to do that, but it takes about 20 minutes. And that's how you can be 99% sure that there will not be a probate with respect to your estate. Again, once you have your final signed documents, keep them in a safe place. The attorney will, of course, have a scan of your final signed documents. And then the healthcare directive is the only one that you would distribute, and you would give that to your medical practitioner or your medical team. Keep in mind, you can always change these documents so long as you're alive and with it. So you want to take that estate planning binder down every 2 years or so and look at your decisions and make sure you're still comfortable with your decisions. If you are not, you contact your estate planning attorney and let them know that you want to change all of your documents or want to change your second named agent on your healthcare directive. And once again, that is absolutely fine as long as you have legal capacity and are with it. Next slide, please. This slide goes to updating estate planning documents. So all the people here, frankly, did not update their estate planning documents. So we have Barry White, who had created an estate plan and thereafter was separated from his wife for a very, very long time and had a new partner, but never got formally divorced. Unfortunately, he did not update his estate plan, and there was years of litigation between the long-term partner and the soon-to-be ex-spouse arguing about where money and assets should go. The attorneys made a lot and the recipients got some, but I think the attorneys really did best in that situation. Heath Ledger, he had completed an estate plan and then thereafter had a child, and he never updated the estate plan to consider that child, and then he passed away. So once again, there was a lot of litigation because he failed to update his estate plan. So try to do that when you can. Sometimes people do it after the New Year's every year just to kind of put a marker there to revisit some of their decisions. We also want you to look at your beneficiaries on your retirement accounts and life insurance. So some of you have had the same employer for 15 years and indicated some beneficiaries when you started to contribute to your retirement account 15 years ago. You may have gotten married since then and forgot to update your beneficiaries there. So it's really important to contact the entity that has that retirement account, contact the entity that has your life insurance policy, and let them know that you want to view your beneficiary designation page. Look at it. If you like it, fine. And if you don't, tell them you need a new beneficiary designation page, and you can easily indicate new beneficiaries. Sometimes they need to be notarized, and send that back to the company. Next slide. So this is our information. Again, we help people throughout California. We're just a team of attorneys with all kinds of housing issues and some financial problems and credit reporting problems. We also do estate planning. There are many estate planning attorneys in your area. So if you know someone that you're comfortable with, please just go ahead and contact that attorney and try to get the process started as soon as possible. You may call our office as well. So here's our number. If it does go to voicemail, we have a strong administrative team that checks voicemail frequently. And on our estate planning attorney team, we have about 4 estate planning attorneys. So if you do want an appointment with one of our estate planning attorneys, you just call and let them know that, and they will connect you with one of our attorneys and make an appointment with you. Next slide, please, Hilda.
That is the last slide.
Okay. All right. So now, thank you so much for holding all your questions till the end. I would encourage you, for any questions, you probably don't want to reveal personal information with these questions. So keep it rather general if possible. This is a public forum. But I'm happy to answer any of your questions. You can raise your hand and Hilda will call on you and let you ask me.
So we have 3 questions in the chat already.
Mm-hmm.
And the first is, can we name a guardian for kids under 18 years old in the trust? If not, what will be the name of the tool in this case?
Okay. Very good question. So when you're choosing guardians, you typically name the guardian. And again, kids only need guardians until the age of 18. That's the family, essentially, or the person you would want your children to live with. It has nothing to do with the money, frankly. So just because a guardian is only needed until age 18, you might want money for your child, if you weren't here, to stay in trust, to be used by your trustee for that child, college, housing, whatever's needed, until 25. And that can certainly be in place. But a guardian is basically where you would want your child to live if you were no longer around. So You typically name a guardian in a trust. We oftentimes do it in the pour over will as well, and that's a document that goes with the trust. If you don't need a trust and for whatever reason don't want a will but want to indicate a guardian, we can prepare what's called a nomination of guardian document, and that just addresses guardianship. So it would be a nomination of guardianship document you would want if you don't have assets that exceed $184,500 and don't want a trust. You can definitely do that.
We have another question. Is a transfer on death deed necessary if a trust has already been created and is in place?
Very good question also. It is not, because it's very important to not have conflicting instruments there. That's why it's important. Seems like you've done some of this, Joe. If property is already in a trust, you certainly don't want to do a transfer on death deed, because that would probably conflict with the intentions of the trust. And this is, I'm assuming that the real property, your home, is in the name of the trust. So the trust will take care of it, and you do not need a transfer on death deed. All those tools is typically for each asset, either or. You don't want two different tools applying to the same asset. That'll just cause a problem down the road.
Our next question is, could you summarize the fund your trust part again, please?
Sure. Good question, Lourdes. So once you create a trust, it's a shell document, and you want to put your own assets into the trust. So if you create a trust, and this is why you want an attorney, they will have asked you, oh, do you want a home? That's probably why you need a trust. They will have obtained your grant deed from you. So when you have a trust, they're going to create a new grant deed where you're going to convey your interest in this townhome to yourself as trustee of your trust. That's called funding your trust, putting your own stuff into your trust. So it doesn't mean buying new assets or having a lot of money or anything like that. It just means putting what you currently have into your trust, retitling it. Likewise, if you have a bank account and you want to put it into your trust because it tends to, get kind of a decent amount of money in there, you are going to go to the bank and say, hey, I have a trust. I want to change title on my account to me as trustee of my trust. And you're going to show them the first few pages of your trust to do that. And then your statement is just going to look a little different. Thereafter, let's say you sold your home. Let's say, Lourdes, you have a home, you put it in the trust, you decide to sell it. It's fine. You sell it on behalf of your trust. As trustee of your trust, you will sell the home. And then you would purchase the new one in the name of your trust. And you would just give an abbreviated version of the trust to your title company, and they will put your new home into the trust for you.
Great. And we have one more question. By the way, you all, we have a couple more minutes. So if there's any more questions, I believe we have a little bit of time for one or two more after this.
Absolutely.
What is the average cost of implementing the trust?
Okay. And by a trust, I'm thinking an estate plan, because typically it's the trust, a couple of documents that go with it. It's the new deed for the trust. It's the pour over will. It's the power of attorney, healthcare directive, and HIPAA. So I'm kind of thinking of it as a trust package. I would say it's usually between around like $2,500 to $3,500 to do all of that, create the new deed, etc. And you can probably perhaps find someone a little bit less expensive. We charge on a sliding scale, so we base our fees on what last year's gross income was on your tax return, and this is for the prior year. So that's how we charge. But yeah, I think it's the couple $1,000 mark is the average here in California.
Got it. Okay, so it looks like we are out of questions now. There was a lot of good questions, but thank you so much, Kendra, for that very informative presentation. And to everybody out there in the audience, if you missed any part of the presentation, it will be available on our YouTube channel shortly. Our next streaming program is the Spanish version of this program called Planificación Patrimonial with Hera as well. It will be on Thursday, May 30th at 12 p.m., same time, same place. For more information on this program and all of our streaming programs in this series, please visit us at lapl.org/housing rights-right. I said that all wrong, but it's on the screen. Thank you all again, and have a great rest of your day.
Thank you.